Hi, today I wanted to cover 5 things your insurance adjuster doesn't want you to know. I'm attorney Pedro Juarez. I'm an attorney in Boston, Massachusetts, and I focus on personal injury cases, specifically motor vehicle accidents. Before I became an attorney, I was an adjuster for over 10 years handling motor vehicle claims, and I was a supervisor for another 5 years before I went to law school. Okay, we'll go ahead and get right into it. First thing, low initial offers. So adjusters will often start negotiations after you make a demand or after you reach tort. Their first offer is always going to be a very low offer, and you should, as a matter of rule, never take their first offer. They're hoping that you accept it before you realize the true value of your case, or before you talk to an attorney. Settlement negotiations are a process. It's going to take several conversations. There's going to be a lot of back and forth before you actually get to a reasonable settlement. In some cases, you may have to produce further documentation. You may have to produce an expert report. You may have to produce witnesses. You may have to produce your prior medical records um, in order to kind of substantiate your claim. And sometimes you may even have to file a lawsuit. In some cases, you may also need to go through some type of alternative dispute resolution, something like mediation or arbitration. Just be careful in some cases, though, if it is binding, if they force you to binding mediation or arbitration, that may preclude you from having a jury trial, which is, again, one of your absolute rights. So just be mindful of that. Negotiations are deeply psychological, meaning that you're never going to get the insurance adjuster's best and final offer at the start. It's a process, and the other side is always going to want to look for a discount on your claim so they can look good for their boss and employer. And lastly, if you don't have an attorney that represents you for your case, then insurance companies, they're going to try to exploit that and take advantage of you because they know that you don't understand the process, you don't understand the legal aspect of it, and they understand that you don't really know the full value of your case. So they're going to lowball you. There is a premium that insurance companies have to pay if you have an attorney. Similarly, there's a premium that insurance companies will pay on your case if they know you have an attorney that is willing to take the case to trial. Uh, this one, diminished value of property claims. This is more not on the pain and suffering on your injury, but more on your property damage case. For many years, insurance companies always refuse to give you what's now called inherent diminished value. So this is, for example, you bought a brand new car. Yes, you drive it off the lot and it loses value, right? But it's still brand new, and now it gets into a car accident and it gets repaired. Well, naturally, it's going to lose even additional value, right? If you go and sell it and somebody runs a Carfax report or whatever type of report, and they see it's in a car accident, I'm not going to pay the normal price that I would typically give you. Now, if you're trying to sell it, I'm going to want a discount because it's been a car crash, and God knows the quality of repairs, if something else broke, if there's now mechanical issues or electrical issues, right? So claimants would try and get compensated for this difference that now they're kind of left carrying, and insurance companies always refuse. So recently, there was actually a case that went to trial, and the court agreed that these claimants, these vehicle damage owners, did have a valid claim, and insurance companies are now required to pay for these damages. Obviously, you need to show that your car suffered some type of inherent diminished value, and that you're obviously owed this money. So this wouldn't apply to your own insurance company. So you would have to be not at fault for the accident, and you would have to make this claim against the defendant or the other person's insurance company, again because they would have the liability, and you would have to show, you probably have to do some type of either get an expert or um, you know have some documentation showing that now your vehicle has lost significant value because of the car crash. Legal time limits. So there are statute of limitations of how long you have to file a claim. In Massachusetts, you have 3 years to bring a personal injury claim from the date of the incident. So if you have a car crash, trip and fall, whatever, you have 3 years to file a claim or file a lawsuit to preserve that. So that means if you don't file a claim and your claim doesn't get settled within those 3 years, then guess what? You're out of luck. So you either have to settle that claim within those 3 years, or you need to file a lawsuit to preserve that time limit, or else you're going to be barred from making a claim. And insurance companies, they're not going to tell you this. They're not going to make it obviously abundantly clear. They're going to kind of wait it out, and either you wait for you to get an attorney or see if you're savvy enough to push for negotiations. Again, not saying that insurance companies do this on purpose, but sometimes you know they like to play dumb. Additionally, if some insurance companies, if they commit or some if an insurance company commits an unfair or deceptive business or insurance practice, there's a statute of limitations that's actually 4 years for you to bring the claim from the date of the omission or of the bad faith act. So there's a little bit difference there. So bad faith claims, you have 4 years. Personal injury cases, you have 3 years. All right. So what do you need in order to bring a claim? So there's this legal principle called tort. So you have to have a tort threshold in order to be able to make a claim against the other party for injuries that you may have sustained. In Massachusetts, for a motor vehicle accident, the threshold is $2,000. You need to have $2,000 in related medical expenses in order to bring forward a claim, to have a valid claim. Now, there are some exceptions. Obviously, if there's a wrongful death, if you lose a body part, if there's some type of disfigurement, if you lose sight or hearing, or if you sustained a fracture. So, obviously, if you sustain any of these, you're probably going to have way more than $2,000 in medical expenses. But in the event that you have one of these exceptions and you don't have $2,000 in medical expenses, which would be a rarity nowadays, you can still bring forward a claim. A couple other nuances. There was, if you're with the MBTA or you're riding a bus or a train, the MBTA is actually exempt from carrying what they call no fault or PIP benefits. So there was a case where it said that even if in cases where you are exempt from carrying no fault coverage or PIP benefits, um, that does not preclude you from bringing forward a pain and suffering claim. Um, so even though they may not pay medical expenses, that's fine. If you don't need $2,000 in medical expenses. All you need is $1, and that should be sufficient to bring forward that claim. Same thing for motorcycles. So in Massachusetts, there is no fault or PIP benefit on motorcycles. That's a matter of law. So the rule is that even if you get hurt on a motorcycle and if it's not your fault, even if you didn't incur $2,000 in medical expenses, but you incurred at least $1, you could still bring forward a claim. So there are other exceptions to the $2,000 threshold. Lastly, medical and health insurance liens. If you settle your claim too quickly, the insurance company may not tell you that your health insurance has a right to get repaid for any medical expenses or benefits that they paid related to the accident. This includes your private health insurance, Mass Health, or Medicare. Again, they could potentially have especially Mass Health and Medicare, and even your private health insurance. It's all written in their contract that if it's related to an accident, they have a right to be repaid. So If your insurance company offers you a low settlement, guess what? And if you don't know enough to negotiate down these liens, you may be left with no money or very little money. So just being aware of this is going to be helpful. Even if you don't have private health insurance, the state and federal funded health plans, they have a subrogation right. Excuse me. Okay, so uh, just a disclaimer. This is not intended to provide you any legal advice. Doesn't create any attorney-client relationship. The law is very fact specific, and your particular situation may not nicely fit into one of these general statements that I just made. This is just for general educational purposes, not case specific. If you do need legal advice, please contact an attorney in your state, or somebody that you trust or that's licensed to practice law in your state. If you do have questions about motor vehicle accidents, feel free to reach out to me. You can send me an email with a brief description of your situation, and I'll get back to you. We can maybe set up a consultation, or I can just um, reach out to you by phone to talk about your situation. I hope this was helpful, and thanks for watching.